Thank you very much, and thank you for this opportunity to be here and to talk about the U.S. laws and how they may be applicable throughout the world and in Bosnia. I also want to thank the Chamber, I want to thank Luna, I want to thank the U.S. Embassy for their sponsorship, and all of the persons in Bosnia who've been working on whistleblower issues and have had some success in passing an initial law and I think raising public awareness of these needs. And in many ways, the work here in Sarajevo and throughout the country is trailblazing in Eastern Europe and in Europe, let alone other countries that have absolutely no protection for whistleblowers. Just before I begin my formal remarks, I have put on the board the definition because many people don't know what whistleblower means. And just to repeat, if you go to number 2, it's one who reports fraud, corruption, misconduct, and violations of law to the appropriate authorities, often risking his or her financial security, or worse, to protect the public interest. And number 3 specifically discusses bribery as a target for new whistleblower laws, one who discloses bribery. So whistleblowing is nothing unique or controversial. If you want to know if corruption exists, you need someone to tell you about the corruption. And since no one takes bribes publicly, they don't sit on the street and hold up a sign and say, "Give me my payout." Bribery is done secretly. Corruption is done behind closed doors. It's done privately. It's designed to be hidden. So without a source of information, without an insider who can talk to you or give you the evidence of the corruption, it will be undetected. It's as simple as that. So the protection of the source, the whistleblower, the informant, it's critical for anti-corruption. So in the United States, and I think in the rest of the world, including this country, as the debate on whistleblowing continues, what is important is it is not about whether you like or dislike whistleblowers, if you think they're finks, if you think they're informers. It doesn't matter. The focus is on anti-corruption. Do you want to detect fraud and bribery? The answer is yes. You must encourage and protect your sources. It's as simple as that. Those who profit from corruption hate whistleblowers, period. Because they understand their power. They understand their impact. But so it's critical for those who are the victims of corruption, which is the overwhelming majority of the people, to understand that their best friend is the whistleblower. Because that's the source of the information. It's where you go beyond the grumbling, beyond the cynicism, beyond they're just ripping us off and we can't do anything about it, to there is a way. And what is amazing about whistleblowing, and I will get into that, is that it actually works. It works in ways that I believe are not even understandable in most countries of the world, because it works so well. It is hard for people who have been victims of corruption for years to actually envision a system that can be effective in detecting and enforcing anti-fraud laws. It's just hard to imagine it. And it was hard to imagine it in the United States. And when these laws were first passed, and I was there when some of them were passed, I've been doing this for over 30 years, no one saw it. People felt bad for the victims. People felt bad for the whistleblowers. People knew you needed the sources. But I don't believe anyone understood the power and the effectiveness. I myself didn't. I saw these laws, some of them being passed. I started practicing law in 1984, and the first real powerful whistleblower law was in 1986, 2 years later. And it was really impossible to see how it would unfold. But it has. And it has resulted in other laws being passed. And it has resulted in real change. And the program can be duplicated worldwide. There's nothing unique about it. And there's something else that happened in 2010, again, with no publicity. And it really has just taken shape in 2014. It was one of our laws, one U.S. whistleblower law, has worldwide application, meaning any person in the world can report bribery in violation of this one law and get protection and rewards in the United States. And I'll explain that. But what's so important about that particular law, it's really the first time that persons who are fighting corruption in countries for which there is no protection whatsoever can actually come to the United States anonymously and confidentially and obtain rewards. And in fact, in 2014, the United States paid over $30 million to foreigners who reported bribery in their own countries. And in my calculation, that is more money paid to whistleblowers than under every other law in the world. If you look at the English law, if you look at every other provision of any law in any country. So just in its very infancy, it has had a major impact. And that's part of what I want to explain. So let's first explain why whistleblowing is key. And it's this chart that is on the board now, detection of fraud. This chart was put together by the Association of Certified Fraud Examiners, an organization of 25,000 auditors worldwide, and they studied how fraud is detected, because that's their job. And the study is scientifically based. It was a survey. And I've seen many other studies from other groups, and they're all the same. This is just an example. And what you can see here is they broke it up by region. Here's the United States. I'll just point to it. And you can see it's the black one here. But here's Eastern Europe and any other area of the world. And you can see that the tip, which is the source from a whistleblower, is by far the largest source of information on fraud. You can see notified by law enforcement is very low. And that's not to be critical of law enforcement. But how does a regulator or a policeman learn about fraud? From a tip. They need a source. And what this organization said, that this number, the tip number here, is radically understated. They said that most countries have no procedures to encourage tips. Even the United States, when they look at the numbers, the majority of people do not report. So they said that if you set up a system to encourage insiders, whistleblowers, to report the fraud and corruption, that is the key. And it's just pure science. As I like to say, love them or hate them, if you want to find it, you need the tip. And if you want to make it really effective, encourage that. As I said, our first whistleblower reward law was passed in 1986. And this law changed the way you look at whistleblowing. Most people think of whistleblowing as a way to defend a victim of retaliation. Someone reports corruption, they get fired, so you need a whistleblower law to get them their job back. Most laws are structured that way. Most people see whistleblowing that way. Protect the whistleblower from the retaliation. Well, this law was different. Fundamentally different. Yes, it protected whistleblowers from retaliation. But it set forward a reward structure. It said, why wait for the employee to be fired? We want that whistleblower to be working. We want them on the job. We want them inside the organization that is corrupt. We want them collecting information and giving it to us, not fired looking for a job. So how do you achieve that? And he achieved it by saying a whistleblower takes the risk of losing their job and career. Everyone knows it. You become a whistleblower, you become a source of information to law enforcement, and you are at risk of a catastrophic employment situation or worse. So how do you get the person to take that risk? So they decided to set up a reward structure. That if you, the whistleblower, give us the good information, and we're able to use that information to actually prove a fraud or corruption, you get a percentage of the sanction. You get a percentage of what the government collects. So this would encourage the whistleblower not to blow the whistle to the public and start, what you might imagine most whistleblowers do. It would encourage them to give high quality information to the police. And it would encourage them to take that risk. It also set up a procedure where it would be confidential. In this first law, it's confidential throughout the entire investigation. In the new laws, it's confidential forever. So they just set this up and let's see what happened. And this first law dealt with government procurement only. Fraud in government contracts. What this chart shows is the evolution of the law. It was passed in '86, but in 1988, when the cases first started coming, if you see the blue is what law enforcement was finding without the whistleblower. This was the police, the government, investigating fraud and contracting, and how much money they were finding. And although it's hard to read this, that happens to be about $55 million. The red is what was coming in from the whistleblowers. And that first year was like 17 million. And so then there was the total amount brought in. The green is the total amount. But as the law got well known and as it was used, look what happens. The amount of fraud being detected by the whistleblower shoots up. The amount still being found by law enforcement goes up but remains low. And total recoveries skyrocket. So in 2012, whistleblowers were 80% of the fraud recoveries. So don't think about whistleblowers getting their job back or a whistleblower fighting a retaliation case. Think about the whistleblower as the source of information and as the key to fraud detection. And that's what they saw here. The numbers just keep going up. And that's what you would expect. So now let's go see what, and I'm not talking about whistleblower advocates like myself. I'm not talking about NGOs, nonprofits, or even whistleblowers. I'm talking about what do the top law enforcement officials in the United States of America say about these whistleblower laws. This is the United States Attorney General. The impact has been nothing short of profound. And that's the concept you need to keep in your mind. By unleashing these sources of information on fraud, it has had a profound impact on the ability of law enforcement to police bribery, fraud, and corruption. This is also the United States Attorney General, not a big whistleblower guy. Whistleblower reward laws have provided ordinary Americans with the essential tools to combat fraud and bring accountability to those who would take advantage of the government and the taxpayers. The key in this quote is ordinary Americans, and that's who the whistleblowers are. I have worked with them for 30 years. They are not extraordinary. They're your neighbor. They're your fellow worker. Before, often in the press, you may see them after they've been retaliated or after they've lost their job. But mark my word, before they've suffered those humiliations, they're just like everyone else. And the whistleblowers who are coming forward now, they are just ordinary people, but who now have a mechanism to report and report effectively. Ordinary Americans with the essential tools to combat fraud. Let's be realistic. Without the whistleblower and these programs, corruption is rampant. It's everywhere. It was in the United States and still is. It's in your country. It's in Greece. It's in Russia. It's in China. So you need the essential tools. Now, this is a quote from our Assistant Attorney General, who's actually with the responsibility over the program. These laws are the most powerful tool the American people have to protect the government from fraud. Just sit back and think about that for a moment. The word used by the Assistant Attorney General, who again is not some whistleblower leader, he's just a top cop, the most powerful tool. So why am I here in Bosnia today, and why do I do this in other countries? Because you need the most powerful tool. If you're going to fight corruption, you can't fight it with both hands tied behind your back And every time a source steps forward, every time a courageous whistleblower steps forward, they become a poster for why never to blow the whistle. They become an example of what happens to you. They lose their job, they lose their career, they're humiliated. So instead of the whistleblower promoting anti-corruption, those in power, those who profit from the corruption, can use the whistleblower to scare everyone into silence. But these laws are totally different. The whistleblower comes forward anonymously, confidentially. The whistleblower gives the high-quality information to a law enforcement agency that has developed a reputation for protecting the whistleblower, at least not revealing their identity, and doing a good investigation. And all of a sudden, everything changes. And what's amazing about the anonymity and confidentiality provisions is I have done cases in Europe in which, against large institutions, in which those institutions have no idea there's a whistleblower. They have no idea that among them is someone giving the information. And then they're surprised that their sanction is so large, or that they've been caught. And it's that change that starts making people change their behavior. In the securities area, just so you see, they passed a law in 2010 for securities fraud. This is now the chairman of the U.S. Securities Exchange Commission. They're responsible for all frauds on publicly traded companies, so it's trillions of dollars in transactions. They also have half the responsibility for the Foreign Corrupt Practices Act. The whistleblower program rapidly becoming an effective force multiplier, generating high-quality tips, virtual blueprints. Again, that was a law passed in 2010 that's really just coming into focus now. So that's just the background. Now let us go look at one particular whistleblower law that can be used by the citizens throughout the world, which is the Foreign Corrupt Practices Act. And this law can be used right now. Okay, actually, before I go into that, I just want to go over what are the key features of these effective laws. So you understand, if you're going to do an effective whistleblower law, how is it structured and modeled? The first is that they guarantee to the whistleblower between 10 to 30% of the recovery. I want to make clear what that means. That's the amount the government actually collects. So if the information you give results in no collection, you get no payment. You're still protected from being fired, but you get nothing. Why is that important? When a whistleblower comes to me today and they say, should I take the risk? I look over their information, and if it's high quality and good, hey, it might be worth taking the risk. Let's put it together. But if it's not good information, I can advise them, do you really want to risk your job? So what this does is it focuses on getting the best evidence against corruption. It focuses the whistleblower on the actual mission of the law, fight corruption. It also says that only if the government gets the large share does the whistleblower get anything. And the 10 to 30% is based on how good your information is. The information must be original. And that's really what it's all about. Get original information from the insider. As I said, there's strict anti-retaliation and confidentiality protected. So what we mostly think about a whistleblower, don't fire them. Those laws exist. But I will tell you, if you have to use the anti-retaliation law, it's not a good thing. It's best to remain confidential, and it's also best to get the government behind you so the company or the agency knows you are a witness, and they'll be more afraid to take adverse action. Here's my favorite part. Participants can obtain a reward. I want to repeat that. If you participated in the illegal activity, you still qualify as a whistleblower. Now, many people shake their heads and say, what are you talking about? Whistleblowers are these nice, honest people who are like the heroes and heroines of our society. They would never steal a paperclip. And that might be true to many people. But remember, these laws are designed to fight corruption. And the participants in the schemes often have the best information. But also think about it. If 5 people are working together on some bribery scheme, and one of them can turn it in and make a lot of money, that undermines the conspiracy. The ability of a participant to anonymously report on their co-conspirators is just a gigantic, effective mechanism in fighting corruption. Because the purpose of these laws are to eliminate corruption, not declare the whistleblower the hero of the day. But I will say this. If you are the person who planned the fraud, initiated the fraud, then you're in a different category. The kingpin, the mastermind, those who created the fraud, they are often excluded from protection. So there's a difference between a participant and a mastermind. So for example, a Swiss banker. The Swiss banker has illegal clients. They have illegal offshore accounts. They solicit business. They are a participant in money laundering, but they're fully protected. Whereas those who may have created the systems may not be. So it's just a situation that I think many people don't understand. That's the basic framework. I'm now going to talk about the Foreign Corrupt Practices Act, which is today the leading transnational whistleblower law open to every citizen of the world. Just so you see what's going on before I get into it, the countries in red are where foreign nationals have actually used the law today to report bribery. And you can see it's happening everywhere. What is amazing about these numbers and this map is that I don't even understand how these people are learning this law exists. But they are. And what it means is a person in Saudi Arabia here can disclose a bribe paid to a Saudi government official by a company to get a business advantage, and that Saudi citizen can come to the United States anonymously, file a claim, and if that bribe is proven and a sanction obtained, that Saudi citizen can collect 10 to 30% of the award, of the sanction, anonymously and confidentially. So no one in Saudi Arabia knows who this person is. No one may even know there was a whistleblower. They came here and they get it. And as I said, they've paid $30 million already just in 2014. These are, since the law was passed in 2011, that's when the law was passed, already 1,136 foreign nationals from 83 different countries have filed these claims anonymously and confidentially in the United States, reporting bribery, in all these countries. Look at that. Ukraine, Greece. The largest ones clearly are those that speak English because they can read about it in the newspapers and they can understand this law has been passed. Many of the cases in China I know are coming out of Singapore and Hong Kong. Many people speak English and they have access to the West. India, their legal system is in English. But these laws are open around the world to everyone. This is what the United States Securities and Exchange Commission publicly released in a report when they announced their $30 million given to a foreign national for reporting corruption. In issuing the $30 million award, the Commission specifically noted that allowing foreign nationals to receive awards under the program best effectuates the clear congressional purpose. So don't take my word, that is the officials of the U.S. government saying we're paying foreign nationals. We are accepting the claims worldwide. And I will tell you right now, from having worked with those investigators, they are serious, they are competent, they will honor confidentiality, and they're conducting thorough investigations. What is shocking to me is that it's only the United States doing this. So let's see why that is, I think, should be shocking to everybody. Under the Foreign Corrupt Practices Act, these are some of the sanctions paid by foreign companies to the U.S. government because they paid bribes in other foreign countries. So this company from the Netherlands paid $125 million for bribing foreign officials to get construction contracts. Lucent from France paid $137 million paying bribes in Latin America. BAE, a British arms company, paid $400 million. Siemens, $800 million. And this is the only exception, KBR, Brown and Root, and some other oil companies, $1.28 billion in sanctions because they paid bribes in Nigeria. And there's many others. But this is the power of the Foreign Corrupt Practices Act. The sanctions are very large, and I can explain those. And now whistleblowers would be collecting between 10 and 30% of these monies. It's a lot of money. Ask yourself a couple questions. First, these bribes are being paid, say, in Nigeria, but the money's going to the United States. United States government's collecting at $1.28 billion. Are they giving that back to the people of Nigeria? What are the people of Nigeria doing? Do they not care? What are the people in England doing? Do they not care? Do they not want to get these sanctions and penalties? I find that just, to be honest with you, mind-boggling. That this structure now is in place. It's completely effective. It's collecting hundreds of millions of dollars in penalties. It's policing bribery. And it's like, does anyone else want to make any, use this to stop corruption in their countries? I can't figure it out. But the law is effective. So let us just talk about what this Foreign Corrupt Practices Act covers. And it would cover any citizen in Bosnia if they have direct information of who I'll explain, coming in to make a payment to a government official to get a business advantage here. Whether it's a bribe to, say, sell your pharmaceuticals to the local hospital. We've seen those cases where drug companies have come in and paid money so they buy their drugs or their medical equipment. Whether it's to get a construction contract, there's a bid out to build a road and they want their people to get that contract. It can be any type of money paid for a business advantage. So let's see who is covered. First, foreign corruption. The word bribe is very broad. It includes paying anything of value to obtain a business advantage. They understand that someone may not put the cash in a bag and hand it over. So they even cover things like if they give people extravagant vacations under the gauze of a business trip. Anything of value to induce to get a business advantage. Very large penalties. I'll explain those. $5 million for the bribe, that's up to $5 million. $25 million for not having accurate records. You're required to have very accurate record keeping if you're a company covered, and most people don't write in their ledger book, $3 million paid in bribes. So they usually get caught with inaccurate records, they get caught paying the bribe. But the best part is something known as disgorgement. All ill-gotten profits must be paid to the U.S. government. So if a company came in and paid a bribe to build a road, and because they got that contract, they paid a $50,000 bribe, they profited $100 million, they're going to have to pay the $50 million, they have to pay the $100 million back to the U.S. government on top of all the other fines and penalties. That's why the numbers go so high. That's how you can sanction companies $1 billion or $500 million. Because once you're caught, you have to disgorge your ill-gotten gain. Okay, so the law covers U.S. persons. That's how it's done in the United States. You have to be a U.S. person. How else can the United States enforce these bribes? So who is that? Well, it's me. I'm a U.S. person. It's any U.S. company. It's a subsidiary of a U.S. company or an agent. But it's also other companies worldwide that sell their stocks to Americans through a system known as American Depository Receipts, ADRs. So a company that is traded in London and has no American employees and pays a bribe here in Bosnia, but sells their stocks to Americans on the London Stock Exchange, guess what? They're covered. So in reality, this law covers most of the worldwide publicly traded economy. So it's very broad. That's why when we looked at some of those companies, that's why they were getting sanctioned. Non-U.S. citizens, as we've already said, and you must get 10 to 30%. So is this law perfect? Absolutely not. Will it cover all corruption in Bosnia and Eastern Europe? Absolutely not. But does it cover bribes paid by large companies that want to seek a business advantage here and elsewhere? Yes. And I want to add that if you're looking at corruption of high-level government officials, who has the money to make those big bribes? The larger companies. Here's my next favorite feature in the law. Again, think. The law is designed to help detect corruption. So many of your preconceived notions about who a whistleblower is or what it's all about need to be discarded. You need to think, how do we fight corruption? The next step is, how do you get a source of the information? And the next step is, how do you get that source to give the information to the government? So what they did is they changed the definition of whistleblower in the 2010 law that covers the Foreign Corrupt Practices Act. I just want to say that again. They changed the definition of a whistleblower. So you can go and read all your definitions, and that's not what this definition is. So the first definition of a whistleblower is an insider. The classic whistleblower we all have in our minds. The worker from inside. But then they added a new term. The analyst. Repeat that word, an analyst. The analyst is a person who has no original information. None. But puts information together from public or non-public sources and able to explain that the corruption exists. Voila. NGOs, non-governmental organizations that fight corruption, can qualify as an analyst. You still need to be an individual to file, but it can be through the NGO. Why is this so important? Just think it through. There's a whistleblower, say here in Bosnia. Do they know how to file a claim in the United States? Do they speak English? Do they know these laws? But what this law has done, it has actually incentivized any good NGO that's based on anti-corruption to familiarize themselves with these laws and procedures. That organization here in Bosnia or in any other country can work with the sources, can give them more protection, and put the information together and file the claim. So the claim can come through the representative of the NGO or a lawyer or anybody else for that matter. The analyst. It's not limited to an NGO. So, and I believe for the foreign corrupt practices, especially in countries for which there aren't sophisticated traditions, this becomes critical. Because the government wants the information. And they'll take it directly from the whistleblower or from the analyst, which can be the person helping the whistleblower. And it's just there, the definition includes. Major breakthrough. The next major breakthrough is with confidentiality. And again, the word whistleblower is now misleading. When the word itself signifies someone blowing a whistle. And in the old days, that's who a whistleblower was. There's corruption, everyone should know. They'll maybe go to the press. there's wrongdoing, and the public sees them, be it Daniel Ellsberg in America, or Edward Snowden, or other well-known famous whistleblowers. They're known in the public. Okay, that's still protected, that's fine. You can still do that and qualify. But the law understands that the overwhelming majority of sources of corruption won't go public. They're afraid. They don't want to lose their jobs. And the law also understands that you want to keep the whistleblowers employed. You don't want them to lose the job. You want them to remain within the corrupt institution. So the law has now changed and permitting confidentiality and anonymity. Permits individuals who are not U.S. citizens to file with the authorities anonymously. And I'll just explain how that works, and I'll tell you a story about how I've worked it. If you want to be anonymous, and you don't have to be, it's an option, the anonymous whistleblower must hire a U.S. lawyer or a lawyer licensed in the United States. That's a requirement. That lawyer has to essentially sign a sworn statement to the government that the whistleblower exists, that the information they are providing is what the whistleblower provided, and must maintain in secret the original information provided by the whistleblower. So if they ever need to ensure that the whistleblower really existed and was qualified, it's all there. But the claim is then filed in the name of the lawyer acting on behalf of the whistleblower. This achieves two things. First, the whistleblower gets the added protection of attorney-client privilege on top of the legal protection. And second, it gets a lawyer involved in looking over the information so the information can be given to the government effectively. Remember, the government's looking for accurate, original information. So this helps the government process the information as opposed to a whistleblower just turning it all over. So that's the benefit. Now, let me just tell you how it works in practice. So we file an anonymous claim, and this is true story. The investigators get it. Oh, this is interesting. We'd like to talk to your client. So we arrange a meeting in a third country. So this whistleblower is in one country in Europe, so they fly to another country. We fly from the United States to that country. We get a hotel room. We don't even use the embassy because we don't want all that paperwork and whatever. It's just all done secretly. Arrange it. We sit down and meet. And these government investigators are very cooperative. They agree you're not going to take any pictures. If you show them a document that has the whistleblower's name on it, they won't write it down. They won't take the document. If in the course of the conversation the name slips out, they don't remember who it is. They're very cooperative. They're very committed to keeping that anonymity because I've seen it and I've also tested it. They also have to what's known as back source the information. So if the whistleblower says has an email that shows the bribe, they don't take that email and just give it to the company. That might identify the whistleblower. They have to take steps to get the information, often from the company or from other sources, in a way to protect the identity of the whistleblower. And it's all required by law. So for the first time in my 30 years of practicing, I'm actually seeing an effective method to anonymously blow the whistle. And if your whistleblowers are coming from Russia, from China, from Bosnia, from Hungary, from Ukraine, believe me, they need anonymity, period. I don't care what anyone says. There are no protections. They need anonymity. So to summarize, well, we won't summarize. I think this is in the PowerPoint that you can see. Now, I just want to tell one last story and example, and then we'll go to questions and answers. In my view, I've seen three sources of corruption that are the worst. Public procurement, people ripping off the government and contracting, bribery, and tax evasion. And tax evasion that we've seen heavily, is when people either take their ill-gotten money and put it into a secret Swiss account or a secret account offshore, or otherwise move their money to undisclosed offshore accounts to evade taxes and evade detection for, say, they got the money improperly. We already know that it is the amount of money in these illegal offshore accounts is in the trillions and trillions of dollars. One Swiss banker I was talking to just the other day, a whistleblower, estimated it was $11 trillion in Switzerland alone. $11 trillion from the world. So you can think of your own country, and that's where people are putting their money, and also money often stays in these illegal accounts for years, generations. So money may have been put, say, from someone from Sarajevo, was afraid at the outbreak of World War II that their money may not be safe in the local bank, so they moved, $1 million to a Swiss account. That money most likely is still there. It gets inherited. They have procedures for inheritance. The Swiss are very, very careful to make sure they track down the next of kin when someone dies, and they look at the death certificates, and they bring people in. They have a whole program. So if you put your money there, you can rest assured that your heirs will get access to that account, even if they didn't know the account existed. So there's trillions in offshore accounts. So another whistleblower law that is applied extraterritorially is the U.S. tax law. But it only covers U.S. tax evasion. So it's not like a bribe to a local official here can be prosecuted. It only covers U.S. taxes. But by looking at this law, we can see the impacts. Watch this. Well, first, there was a whistleblower. The first big Swiss whistleblower was this person, Bradley Birkenfeld. And he did the reward laws, and the United States paid him $104 million. So he turned in Swiss bank accounts for U.S. citizens, like at the time the largest bank in the world, UBS. The United States sanctioned the UBS bank $780 million for having 20,000 illegal U.S. accounts, and he was given $100 million. That's why I say the laws do work. The IRS, in giving him his award, this is their decision on the award, stated, identified connections and parties, and what's interesting here, they're talking about, while the IRS was aware of the compliance issues, the information formed the basis for unprecedented action. Yeah, everyone knows that there's all this money offshore. Everybody knows that people stash billions and trillions in these banks. But how do you catch it? Well, this guy took the information from Switzerland, flew to the United States, and gave it to the government through the whistleblower program. That's how they got the information. They admit they never would have got it without him. In court proceedings, they said, if he did not walk in the door, we'd have nothing. That's why they gave him so much money. It's the largest award ever given. But they did it because it was phenomenal. You have this massive frauds ongoing and no way to detect it. So what's the better way of getting the bankers to turn in their clients for an award? Voila. So let's see what really happened. Because the Birkenfeld story is not the $780 million that UBS had to pay. That's not it. That's nothing. And it is not his award. It's $100 million. It's a lot of money. No one will say otherwise, but it's nothing in comparison to what was going on. It's a small amount compared to what was really happening. They estimated that United States citizens had $3 trillion in illegal offshore accounts worldwide. So you're looking at a massive fraud. So what the United States did, and they were smart, is they said, okay, we have this whistleblower, and he's giving names, and the Swiss are giving names, and you're all going to get caught. So they made publicity about it. And they wanted a lot of publicity about his award, and a lot of publicity about his case. And then they said, we will set up an amnesty program that if you come in and report your crimes voluntarily and don't wait to get caught, you won't be prosecuted. We won't even tell people who you were. And your sanction is about 20 to 30% of what you had in this illegal account. So if I had $1 million in Switzerland, I could escape prosecution, keep about $700,000, and bring my money back to America legally. So what happened is, in the first report, just so you can see, this is by 2010. This is an official report from 2013. But this is what they recovered in 2010 through people turning themselves in. They recovered $4.1 billion. Actually, as of 2009, 15,000 tax cheats, tax evaders turned themselves in, and they collected $4.1 billion, not $780 million. But that's nothing. Because if you read the report, so many people were turning themselves in, they'd only processed half the cases. They had people lined up to give us their money. So you can estimate that for the 15,000 will come to about 8 to 9 billion in sanctions paid. But guess what? They continued the prosecutions. Whistleblowers continued coming forward. They continued prosecuting other banks. And as of now, the most recent number, January 2015, 50,000 Americans have turned themselves in. Not 15. Who knows how big that's going to go? And that's only the beginning, because that's the money being paid directly in fines and sanctions. Guess what? Hundreds of billions of dollars are now going from illegal foreign accounts back into the legal United States economy, because they have to move the money back into legal banks. The benefits are overwhelming. And this is triggered by a whistleblower through this process. Now, any foreign banker can use this right now. Question: why have no other countries done this? I have seen numbers provided to me by Swiss bankers, and I will tell you the United States is a small overall player in the illegal banking world. A small player. Other countries have far more money. And I sit in utter amazement and near disbelief that all of these countries are doing nothing, where a mechanism to enforce these laws exists. So we'll break for questions in a second, but the takeaway here, the conclusion is twofold. In this first part, there will be a second part of the program, but it's twofold. One is, if you can use the current laws that are available internationally, use them. This will be for a small group of potential claims, but a very significant group. So if you can put the information together about bribery and get it to the appropriate sources properly, and this sanction is paid, I think it will be tremendous both for your country or any other victim country and the cause of whistleblowing, because it really does work. And these laws can be used today, not in everything. So I really believe that anti-corruption organizations and those interested in whistleblower protection need to understand these laws, because if a whistleblower comes forward who fits under these criteria, these powerful, confidential reward laws should be used, and used now. They're already being used worldwide. But the potential is literally completely untapped in terms of the number of cases. Second, these laws provide a model for an effective anti-corruption program that can be duplicated and should be duplicated. So with that, I'd like to thank you. Actually, last but not least, I just want to say this PowerPoint is online, and there's lots to it. And we also have resources online right now, and I'll just leave those right here up, where you can obtain copies of the laws, you can obtain translated information about the Foreign Corrupt Practices Act. We've translated information into about 12 different languages. You can obtain information on how to file claims and what these laws are about. And I recommend mostly this new website we've set up, globalwhistleblower.org. And that has information on it. It has translations into a number of major languages. And it also has links to other resources. So from here, and just using this site, you can find where the Securities Exchange Commission website is for filing claims, the IRS website. You can read the actual text of the Foreign Corrupt Practices Act, and you can familiarize yourself with all of these programs in far more depth than I'm able to get in today. The PowerPoint will be online, as will lots of other information. So with that, I'm going to open the floor to questions. Thank you.
Pitanje koje je stiglo putem e-maila jeste koji je vaš najveći uspjeh u zaštiti uzbunjivača u Americi? Šta je ono što vi smatrate svojim najvećim uspjehom na tom projektu?
Thank you. The largest success was the Birkenfeld case, in which he obtained the $104 million for turning in the Swiss banking system. And the reason it was the largest, it was the first major award given. But he had a problem, which was he was a participant in the illegal banking. He had engaged in criminal activity in the United States because he was a Swiss banker and he had U.S. clients. And he would solicit information or obtain money from the U.S. client to deposit in a Swiss bank for which no taxes would be paid. That's illegal. So you had a whistleblower who was a banker, who did illegal things, and in fact was forced to plead guilty to one of those crimes in the United States. But on the other hand, you had a source of information second to none. It was an absolutely invaluable source. And he wasn't the big wig. He just took the job. He graduated from a school. He got hired by UBS in Switzerland. All the other bankers are doing this. It's legal in Switzerland to do money laundering. It's legal in Switzerland to set up these illegal accounts and not pay taxes, or it was at the time. So in his mind, he's just doing what all the other bankers were doing. But it was illegal in the United States. So we had to convince the Internal Revenue Service, the United States government, that even though he had engaged in criminal activity, he was deserving of an award. And we had to convince them not just that he was deserving the award, but that paying him a large award was absolutely critical for worldwide anti-corruption. Because the purpose of the law is to get the information about the crimes and the frauds. You need the insider, and those are often people who have committed the crimes. So if you set up a whistleblower program but exclude participants, you are cutting off 90% of your sources. So we had to explain how under the law he was qualified, but under policy you must give him this award, and you must make it public, and you must make it dramatic to send the message. Because whistleblowing, one of the most important parts of it is the message it sends. If the whistleblower is fired and loses their job and career, the message sent to all informants, to all workers, is shut up, don't report. But if the whistleblower actually wins, actually obtains a benefit, the message is the opposite. The message is whistleblowing can work. So we had to fight for a long time, and we got the IRS to agree with us that participants are qualified. We then took that and went to the U.S. Securities Exchange Commission, which set up the Foreign Corrupt Practices Act whistleblower program, and we said to them, you must make participants eligible. They were doing rules, and the commissioners were very upset about this. It's unseemly. You mean someone who was paying a bribe can get an award? This is terrible. We said, well, look, the IRS just did it. Read the law, look at the policy. If someone is the planner and the initiator, if they plan and initiate it, we understand they're not qualified. But if you just hire somebody to go and pay the bribe, they need to be qualified. So now we get information, and sometimes people tape or even do video recordings of them paying the bribe. They got the best evidence. They paid the bribe, but they've got the good evidence. So this may seem unseemly, and it may seem contradictory to your preconceived notions of what a whistleblower is. But the new rule is effective anti-corruption. And people will participate. They will do bad things. That's just the way it is. So I view that as our most important victory, not just because it helped Birkenfeld, not just because it got him an award. I think it helped save that program, and it set the precedent that participants can qualify.
Imamo nekoliko pitanja iz sale. Pitanje je da li možete pojasniti razliku između ucjenjivača i uzbunjivača? I da li se može smatrati uzbunjivačem osoba koja nije kredibilna? Ukoliko je kriminalac, ratni zločinac, psihološki bolesna osoba, vi ste donekle govorili upravo o tome, ali evo to je pitanje.
Okay, first the difference the question was the difference between a whistleblower and a blackmailer. That's an easy one. If the whistleblower goes to the wrongdoer and says, I won't report this if you give me money or give me this or give me that, yeah, they're not going to be qualified, and that's a terrible thing. That's not what whistleblowing is. So if someone uses their inside information to blackmail somebody, that is not whistleblowing. Remember, whistleblowing is giving the original information to law enforcement, not to the wrongdoer, not for blackmail. It's to give to the appropriate authority for the purpose of prosecuting the wrongdoing. So we often have whistleblowers approach us and they ask, I don't want to get involved in a big dispute. Should I go to the company and say, hey, I'll give you this, or I won't go to the government if you give me money? In the United States, that's called obstruction of justice. If you are convicted of a crime related to your whistleblowing, you can be fully disqualified. So if you try to get money for not turning in your information to the government, that is a criminal obstruction of justice. And we let people know that. But sometimes people say that innocently, but it is an obstruction of justice. So, again, you need to understand the difference. There's still the whistleblower is the person who is giving the information to the government. The fact that they may have been a participant, remember, you're looking at people who weren't the planners and the initiators, weren't the big wig, but people may be hired or working for them. The next question is not qualified due to background. I did not go into the disqualifications. There are disqualifications. People who do not qualify as a whistleblower. And that is listed in the law, it's on the websites. The most obvious one are the government regulators themselves. So if you work for the U.S. Department of Justice, you can't take some whistleblower information and file for an award. There are other disqualifications. And what happens is, if the whistleblower goes anonymously, our government doesn't know who you are, all the way till the end. But if the government decides they're going to give you an award, at that point, they can require that you provide them with your identity confidentially. They will keep your identity confidential, but you then, at the very end, have to turn it over for the purpose of making sure you are not a disqualified person. And there are criteria. Now, the question was someone who committed war crimes. For better or worse, that is not a disqualification. That is, someone who committed a war crime can still qualify. That is not one of the disqualifications. So there are disqualifications, and they're good. And just so you know, is they're going to look at your role. One controversial part of the Foreign Corrupt Practices Act is whether people who work for foreign governments are qualified. And right now, they are not. So if you're the foreign official who took the bribe, you're not qualified. But if you're the person from the company that paid the bribe, you are qualified. So they're going to look at certain things. And one of the important things about working with a U.S. lawyer is to make sure that you are qualified from the start. So that's that.
Okay, we have a question in English, so I will read it in English.
Okay.
I understand that there has been substantial progress in giving the sources a realistic option to remain anonymous. Will the same kind of treatment of sources apply to those who submit their claims under the pre-tem provision of the False Claims Act. And also I have a question regarding assessment of risk faced by whistleblowers whose identities are disclosed in the process, either purposely or accidentally. There is very little information available on career, professional, personal health consequences for whistleblower. Would you consider witness protection program, including change of identity and resettlement where appropriate, justified, like in organized crime cases?
Do you want to translate that?
No,
okay.
I suppose.
Okay. So the first thing I want to say is that the person first asked about a concept known as qui tam. So just to explain that, there are actually 4 reward laws that are open to foreigners. Foreign corruption is the largest. The qui tam is one that relates to government contracting and procurement, but only U.S. government contracting. But if someone from England or Bosnia or Germany learns that a U.S. government money was not spent properly, either a defense contract wasn't properly spent or procurement things weren't sold, you can apply and you can get an award. This is the oldest reward law. It has confidentiality guaranteed by law only during the investigation. But once the case goes to court, the company and the public can learn who the whistleblower is. The new laws give you confidentiality from beginning to end. However, to obtain confidentiality under the False Claims Act, you can ask the court to keep your confidentiality. So under the Foreign Corrupt Practices Act, your ability to remain fully confidential is guaranteed by law. Under the contracting whistleblower law, you only get confidentiality guaranteed by law during the investigation. After the investigation, you would need the consent of the court. So that's, again, a factor whether you want to blow the whistle or not. The other issue is witness protection, etc. Yes, whistleblowers are qualified for these types of protections. And people have gotten the handbook, and I will go over certain parts of this book that more fully explain these laws. But in here you will also see that under U.S. immigration law, a whistleblower can get political asylum in the United States. So if someone blows the whistle in a foreign country, and if they can demonstrate that that foreign country cannot protect them, and if the whistleblowing was dealing with government corruption, they can actually qualify for political asylum, and many people have gotten political asylum. So if you think of the whistleblower as any other source to the government, they are open to these programs, such as asylum or witness protection. But the difference is you have to ask, and someone has to give it to you. Whereas your right to file anonymously and confidentially is guaranteed by law, and if they use your information to do the sanction, your right to the 10 to 30% recovery is guaranteed by law and can be judicially enforced. In other words, if I go to the Justice Department or the Securities Exchange Commission about a foreign bribe, they have to keep my confidentiality. And if they use my information and I'm qualified, they must give me that award 10 to 30%. And if they don't, I can go to court in the United States and force them to make that payment. I will also say that where these cases have been filed to date, which has been tax court for tax frauds, the tax court has permitted the whistleblowers to proceed anonymously in their courts. So the case is called Anonymous v. IRS. and all facts related to who that whistleblower was is kept from the public. We believe that the other appeals that are filed will follow the same procedures. So that anonymity will travel with you. Thank you.
Kao jedan od iskoraka pomenuli ste NGO-e, nevladine organizacije u statusu analist kao stručna podrška uzbunjivaču. Terminološki gledano, zašto na ovome mjestu nisu pojmovno pozicionirane organizacije civilnog društva kao širi društveni kontekst? Ovakvim pojmovnim definisanjem osiguralo bi se više inkluzivnog pristupa u borbi protiv korupcije, što bi osim nevladinih organizacija aktivno uključilo i akademsku zajednicu i medije u provedbi ovog antikorupcijskog zakona.
I am sorry if there was such. Okay, the question is, I said NGOs can qualify under analyst, but what about academics, the news media, and other groups? So I do apologize if I was not clear. Any individual can qualify as an analyst. Any individual, period. So that individual works for a university, the news media, an NGO, and most important, I should have mentioned this, a competing corporation. They're covered. So I want to talk, I spoke a number of years ago to the U.S. Chamber of Commerce, a meeting in Hungary, in Budapest. And I was receiving complaints from people from U.S. businesses saying, you know, the other guys are getting it, they pay the bribe, and we don't get it because we can't pay the bribe. Well, guess what? If you work for an honest corporation, and that company is told, you want to get this contract, pay $50,000, and you say no, and then you see 3 months later, another company gets that contract, and you know that your bid was better than their bid, or equal, you can qualify, an individual from that company can qualify under the whistleblower law, and turn in the competitor, and turn in the evidence of how that bribe was offered and who offered it. And this was designed, and I can get into some of those quotes. When the United States enacted these laws, one of their central missions was to have fair competition, equality in the marketplace. They did not want companies that paid bribes, that sheltered money, that engaged in corruption, to have an advantage over honest companies. So they wanted to escalate the detection methods. They wanted to expand who could become a whistleblower to help honest companies compete. And the only way that could be done was by having a successful detection and enforcement method. So this concept of the analyst is ultimately one of the most important breakthroughs, because it enlarges who can turn in the information, and it really looks at fair market competition. And that becomes one of the ways these laws, in my vision, will help change the way business is done. So, yes, academics, the news media, competitors, NGOs, analysts, yes, you are now covered under the Foreign Corrupt Practices Act and, for the most part, other whistleblower laws.
What do you think? Why don't other countries do the same thing as the U.S. did regarding the amnesty? Okay, I repeat. What do you think? Why don't other countries do the same thing the U.S. did regarding the amnesty for crimes you mentioned?
I am extremely disappointed, depressed, angry at the reaction of the institutional world, government, and bodies to the growth and development of whistleblowing over the last 30 years. From that very early statistic I showed you under the False Claims Act for government procurement, am I going the wrong direction? I don't know. I'm going to go there. We'll get there. There it is. What you can see is the effectiveness of this whistleblower law grew over time. And literally by about the year 2000, everyone knew it was working and working really well. Because if you look at the year 2000, in this chart, the amount coming in from the whistleblowers was already about 2 times as much as the government was finding itself. They knew it was working. They also knew they had lots of cases in the pipeline that would continue working for the years to come. Because remember, all what you see here is about a 4-year time lag. The cases being turned in 2012, they'll be coming up in 2015-16. Everybody knew this was working. So the United States went and they expanded it from government procurement. They then did taxes. And from taxes, they did securities. I haven't mentioned that. The Securities Exchange Act. All fraud in the stock markets. All fraud in commodities exchanges. The sale of mortgages, oil, diamonds. So then they did foreign corrupt practices. So in the United States, because this law was working, and working remarkably well, they expanded it to the whole publicly traded economy. And the quotes I showed you in the beginning from the Attorney General saying this was the most important law. So we did this over time. And while the United States was doing this, and it was public, and it was known, not one country in the world followed suit. They were not living in bubbles. They read the same Wall Street Journal. They were talking to the same regulators. They knew about the whistleblowers. Not one country did a thing. Not one international institution, like the IMF, the World Bank, the EU, the UN, did a thing. Yeah, I'm angry about that. Because I've had the honor, with the support of the U.S. Embassy and groups like the U.S. Chamber and the NGOs that have brought me around, I've had the tremendous honor of traveling to different countries, talking to their whistleblowers, seeing what they've gone through, talking to honest government officials who'd actually like to enforce the laws, talking to NGOs who really want to fight corruption. Yet the governmental institutions have taken no action. And I'll just say it straight because I think the science supports this. It is the science. If you want to stop corruption, you first must detect it. This is 1 + 1 = 2. The world is not flat. It's as simple as that. If you don't detect, you can't enforce. Yet you have government after government refusing to implement rules and laws that would be effective in the detection of corruption. While in the United States, we've expanded them, and expanded them because they work. Believe me, the United States has this same culture as many other countries. I've done whistleblowing for over 30 years. Not one law I use today existed when I started practicing law. My first big case was for a whistleblower at an atomic weapons facility And there was no law protecting him. He was like many of the stories I hear even here in Bosnia, where people have taken those courageous steps and have blown the whistle, and they can't find legal protection. My first cases, I'll never forget it. Our government, the United States, said this guy blew the whistle at the largest atomic weapons plant in the United States about threats to public safety. What could be worse? And he has no protection, he's on the street, no job, goodbye. And we fought that. And we actually won that case, I don't even know how, to be honest, but we did something. Got the media, got Congress, started pushing it. So 30 years ago, I'm looking at an environment similar to what you see here and what we see in Europe. But we now understand the program. It's been proven successful. Then I used to hear people, oh, that's America. We in Europe don't do that. Well, that's just not true. I've spoken to whistleblowers in many European countries. People in Europe want to blow the whistle. They want to do the right thing. They have nowhere to go. And then these numbers under foreign corrupt practices. There are probably more whistleblowers from Europe traveling all the way over to the United States to blow the whistle than there are whistleblowers in Europe. Not because there are no European whistleblowers, they have nowhere to go and no protection. Why have your governments been so inactive? We, in my organization, the National Whistleblower Center, in our global movement, will do anything in our power to help. Through education, through training, through assisting. Because I think these laws have a universal application, and I think corruption is one of the things that is very bad. I also want to say that what we've learned in the UBS bank case is you can rely upon institutions outside of the corrupt societies to help police the corruption within those corrupt societies. And that's a very important breakthrough. In other words, the Swiss banker, where the whistleblowing is illegal in Switzerland, can travel to another country and obtain protection and awards, even though their own country would persecute them. That also can be duplicated. So it's a point of frustration, and I hope that programs like this help to move the cause of whistleblowing forward.
My practice concerns among other things, of personal data protection, and that's what is my interest to be here today. What about personal data protection of the particular whistleblower in government institution or in a private sector? I assume that there are regulations or requirements in US law that would be applicable to a particular whistleblower, because in Bosnia we have agency for personal data protection, and each company is required to file personal data filling systems with that agency. If that particular private company have some policy about the whistleblowers, in that case they would be obliged to establish personal data filling systems within the competent authority. So in that case, personal data would be protected of the particular whistleblower. So I was wondering, is there anything similar?
Sure.
Yeah.
One of the breakthroughs in whistleblower protection were these requirements for confidentiality and anonymity. Now, in the Sarbanes-Oxley Act, passed in 2002, it required all publicly traded companies in the United States to set up an internal reporting system for which employees could confidentially report concerns or misconduct. So if the companies you represent are U.S. publicly traded, there is that law in the United States, and there's already a court precedent saying releasing that identity is retaliation, and the whistleblower can get compensation just because their identity was released and they suffered nothing else, the keeping of the identity. Now, beyond that, many other companies, because of regulatory requirements, have also adopted programs for internal confidential whistleblowing. These are good programs. The only problem you will have is the enforcement of those rights most likely will be under your domestic laws. And your ability to use the US law will be limited to those companies for which you can get jurisdiction in the United States. However, another regulatory requirement that governs publicly traded companies, and this would include both US companies and companies that sell stocks in the United States, is the requirement for internal controls. I mentioned that briefly under foreign corrupt practices, but part of the US regulatory system is that you need strong internal controls. You need a compliance program where companies can internally ensure that they're following the laws and the procedures, and they try to get workers reporting that inside to make things honest, and internal controls in terms of the ability to audit and track down how money is spent. These requirements are viewed very seriously. And under, say, the whistleblower laws, as I mentioned, the sanction is, the award is usually between 10 to 30% to the whistleblower. But one of the criteria they use is the company's internal controls. If the company had good internal controls, they may not even sanction them, and the whistleblower may get a smaller amount. But if that whistleblower raised the issue inside and they didn't fix it, the odds are they're going to get 30%, and the sanction will be much higher. So there's now two reasons for the protection of the personal data and to have these internal whistleblower systems to work effectively. Reason one is so you can self-report and avoid the penalty. Reason two is if you do get caught, and if you didn't have it, you're going to be sanctioned much more than if you did. There's also something else that's very interesting in the law, and I'll just get into it here. One of the questions that came up under foreign corrupt practices and the securities law was, could company lawyers become whistleblowers? Could people who work in compliance become a whistleblower? Could an auditor become a whistleblower? And what was argued on those who wanted to narrow the definition, they said, hey, we're paying this auditor to find problems. We're paying this lawyer to help us. We have a compliance program. If you let these auditors and compliance people and directors and members of the audit committee, if you let them become whistleblowers, that will undermine our internal governance. People won't do their jobs. They'll get the information and run to the whistleblower office. They won't self-police. Now, big debate over that, and we offered a compromise, which was accepted, which is called the 120-day rule, which says as follows. If an auditor finds a problem and reports it internally, if someone goes to a compliance department and reports it internally, if an in-house lawyer learns of something internally, the company has 120 days to investigate And if they find a violation, to self-report the violation. Then they can escape major sanctions. But after 120 days, every person who works in compliance, in audit, in the legal department can blow the whistle and collect an award. So that puts tremendous pressure on companies to have an effective system internally to review the allegations, to investigate them, and if they find the wrongdoing, report it themselves. So remember that this whole process is about fraud detection and the elimination of corruption. It's not about paying awards. It's not even about protecting whistleblowers. That happens because they're essential to detection. The way they've established these procedures is to encourage compliance and then encourage reporting. I hope that answered your question.
Thank you.
Thank you.
Imam konkretno jedno pitanje.
A very concrete question. So my question is about a whistleblower who blew a whistle, a corruption whistle, and corroborated his report with strong evidence, papers, delivered papers to the prosecution service. Then some individuals were apprehended, and thereafter the arrestees were released from prison. In the meantime, the anti-corruption agency ordered his return to work, but the employer refused to comply with the reinstation order, so that person is no longer employed. You know, he is jobless now as a result, while all of those previously arrested were released and they are back in office. So have you ever heard of such a case, or have you ever dealt with a similar case?
Thank you for that. And the question described a scenario that unfortunately is not unique and that I have heard of both in the United States and elsewhere. The question was a whistleblower found the fraud, reported it to the appropriate authorities, and that whistleblower was fired, and the 10 people, or the people who were engaging in the wrongdoing and who were being prosecuted, all got their jobs back. So the wrongdoers are back at work, and the whistleblower has nothing. And the first question was that typical? And they wanted my opinion. First, it is typical. And it's typical because agencies and companies often want to send a message to their employees not to blow the whistle. So an agency or a corporation will often look at a whistleblower incident, and they may even be sympathetic to that whistleblower. But from a cost-benefit analysis, in their own twisted and corrupt thinking, they know that if they retaliate, they will scare everyone else. They know it. And they know that even if that whistleblower wins the case 10 years later, after a massive court battle, no one is going to want to risk that. So because many employers, both of state agencies and private sector, the behaviors are the same, understand that retaliation can benefit them by chilling and scaring their workers. They engage in it. So what you're saying is not unique. The new modern whistleblower laws try to avoid that circumstance by setting up procedures where that person, that whistleblower, could have gone anonymously and through a reward structure and hope to avoid that, although it often is unavoidable. they will often figure out who the whistleblower is based on the nature of the information, or the whistleblower made a lot of concerns inside the company, then all of a sudden the government's looking at it, they'll figure it out. So that scenario is unfortunately all too common. Now, there is a procedure in law that was designed to address this problem. And yesterday, I was meeting with the public corruption officials here, and we had a discussion, and I was reading the Bosnian law about whistleblowing. And when I was here previously, I met some of the folks who helped implement this law and write it. And one of them told me that they wanted to ensure that the law could be quickly used administratively to avoid long court battles. So I reviewed the law, and I'm of the opinion that the order of reinstatement under that particular law should be immediately enforceable through what's known in the United States and I think in other countries as a preliminary injunction. And this procedure exists in many U.S. whistleblower laws, in which the whistleblower can be ordered immediately reinstated pending the full court trial. And the U.S. Supreme Court upheld this procedure in the 1980s. And it's been incorporated. So what it means is a government investigation alone can make a finding, and based on that finding, the court must put that whistleblower back to work immediately. And then the company can fight the case for as long as it wants. 10 years later, who cares? But that worker is working throughout and never has to give their wages back. They get that money and they work throughout the process. That procedure was established because our Congress understood this chilling effect. They knew that if you fire that whistleblower, it'll scare everybody. And the only way to counter that would be to get that whistleblower right back to work. Because the immediate reinstatement would then have the opposite effect. It would show to the other workers that the law works, that the individual employee can beat the big company or the big agency, that it is not hopeless, that there is an avenue. So this procedure for immediate reinstatement, in our view, is a key feature in every anti-retaliation law. I believe, in reading the Bosnian law, it exists in that law because of the way the law is worded, and I can address that later. But it is a key feature. So I don't want to, my emphasis on the U.S. reward laws, I don't want to de-emphasize the fact that strong anti-retaliation laws are still needed and are really the cornerstone because for years to come, many whistleblowers will be fired and they will need those retaliation laws to protect themselves. So that this provision is a critical provision, and I believe it's in the Bosnian law, and I think it should be fought as hard as possible to make sure if it is there, it's used, and if it's not there, it's put there tomorrow.
So we have a few more questions, but let us conclude with this. So what is your impression of Bosnia and Herzegovina's efforts to fight crime and corruption?
The question is my opinion of Bosnia's efforts to fight corruption. I first want to say I've had the honor of meeting in my last trip here and in this trip with government officials whom I think are dedicated to fighting corruption. I think that's very important. You do have people within your government who want to fight corruption. I've also worked with NGOs, Luna and other groups, which understand these issues and are very dedicated to fighting corruption. And there's also the support, at least from the U.S. Embassy and probably other embassies and entities, but definitely from the U.S. Embassy. So in that way, Bosnia is ahead of many, many countries. They actually have some organizations, government officials, and an embassy that's backing it up. I think that's why this first law was passed. Whether you have the political power to force the government to go all the way in and really protect whistleblowers properly, that remains to be seen. That's one of the reasons why I'm here this week. That's why we're having Whistleblower Week. We're again trying to come back, trying to make the current law work well, and trying to push things forward. I also want to add one other thing about Bosnia, is I've actually met whistleblowers here that are unbelievably courageous, that are in many ways just like the people I've represented for 30 years in America, with two differences. One is some of them have faced life-threatening situations that's more extreme than in the United States. And all of them have taken steps to blow the whistle when they've known there's little or no protection, which means they're truly courageous, and they're really the trailblazers. I also want to say that in the United States, it was the whistleblowers that led the way for all of our laws. Because we would have a scandal, and then they would look into it, and there was a whistleblower who raised the issue. And then our Congress and our American people realized we needed to set up structures so we could prevent the next scandal. So in many ways, you are gifted that there have been these brave whistleblowers to step forward, for they're living proof that you need good laws here, and that there are people who will use them and who will report the fraud and report the corruption and do the right thing. I've been in some other countries that don't have a whistleblower. Everyone's afraid. But you do. And I think you owe them thanks, and I'm very grateful for what they have done. And I want to thank everyone for coming and everyone for listening, and all the organizations that have sponsored this. Thank you very much.